Good afternoon. It is about 1 o'clock on Friday the 27th of November 2020. My name is Aaron Hunt, a partner here at Stace Hammond, and I head up the Migration Partners team here. As always, this should not be taken as being immigration advice. It's merely our comments on what's happening with immigration in New Zealand. To provide you advice, we need to know more about your information, more about your details, what's going on. So please give us a call or an email, and we'll see if we can take you as a client and help you out. Now today we'll be covering 4 topics, and I'm going to leave indicators of the time in the description below if you want to jump to the topic that interests you. Firstly, we're going to look at an update on the skilled migrant visas, as well as a comment on a new resident visa type that was mentioned earlier this year by Immigration New Zealand. Next we'll look at the recent announcement from the Honourable Chris Hipkins about the border, and about the Honourable Chris Fafoy about RSE workers. We'll quickly look at the new border exception for those granted a second and subsequent residence visa, which came through today. And finally we'll look at the strange situation we are seeing regarding border exceptions for partners, especially those coming out of Australia, but also from other countries, and how they're being handled. Now, as we mentioned previously, we had a seminar booked with Immigration New Zealand last week around skilled migrants, the skilled migrant category visa. That was cancelled just before it was meant to commence last Friday, and a new date was set in the software, in the video software, for 10 AM this week, but that also never occurred. Now, INZ have confirmed they haven't set a new date for the seminar to occur, but it will be after the new skilled migrant category policies are announced. Now, no date has been given for that, but they are coming. We don't know when. What we are expecting is the new medium wage requirements, which are typically released in November, so we expect those to come through fairly shortly. However, this is not a typical year, so while it's typically November, that could change, so we don't know when that will come through. But that's what we've got for skilled migrant at the moment. We are waiting for the changes to come through. We don't know when they're going to take place. We were hoping they would be at least announced to us this week, but they keep delaying the seminar because they won't do the seminar until they've released the policies. So hopefully, well, I'm going to say next week, but we really don't know at the moment. Now, in regards to announcements, there's been 2 recent announcements or statements by the government ministers, Hipkins and Fafoy. We'll link them below, either the official Beehive release or an article that details the statements they've made. Now, the first is from the Honourable Chris Hipkins, who stated that he was expecting the border to remain closed for 12 to 18 months. Now, we do agree with this. We've sort of been going on that path for a while now, and that basically means that we won't go back to sort of pre-lockdown situation for some time. It's going to wait until we've got vaccines in place and the worldwide issues sort of sorted out. Even then, it probably might be a country by country situation. We're not going to have an open border as we had previously until, well, for 12 to 18 months, possibly longer. Now, that doesn't mean that the government won't provide more border exceptions. We've seen a number of border exceptions that have taken place since the border closed, and we've got more occurring over time. Now, these are getting spaced out deliberately, which is something actually that the Honourable Chris Fafoy mentioned in his announcement from the Beehive. That was in relation to the government announcing 2,000 seasoned workers in the horticulture and wine industries. Now, this is to assist a $6.5 billion industry in New Zealand, so it is an important industry to the country, and it's still far below the 14,000 or so workers that come in for that industry typically. Now, the Minister has stated that they will be spread out between January and March 2021. The reason being they didn't want to swamp the managed isolation or the MIQ facilities. Now, this will mean that there's less impact on those facilities, allowing residents and citizens to come back into New Zealand, but it will probably further delay other border exceptions that were possibly being considered. So we talked previously about the possibilities of further student visa border exceptions, or perhaps further exceptions for other types of partners from non-visa waiver countries. If they are coming, this is going to further push those back, because the spare MIQ facilities will be used for these regional workers. Next we wanted to cover was the second residence visa. Now, this came through today, the only update we've had today, and it was Amendment Circular 51 from Immigration New Zealand. Now, Amendment Circulars, as mentioned before, are changes to the operational manual, which is of course the rule book that Immigration New Zealand should be following. Now, a change to Y330 now allows people who have previously held residence visas and who received a second or subsequent residence visa overseas to enter the country. This is for people who have been granted that second residence visa on or after 11 September 2020, whose previous residence visa expired between 2 February 2020 and 11 September 2020, and had previously been in New Zealand as a resident but were outside New Zealand on 11 September 2020. So basically, if you're a resident, you were outside New Zealand at some point between February and September, and on the 11th of September you were outside New Zealand, you were typically living in New Zealand but you were stuck overseas, then you have an opportunity there to apply for a second residence visa, and if you get it then you can come across the border. Now, why 330 is an interesting section. We'll actually come back to that in a future video. There is an issue in that section, but we're still looking into the legalities and how it applies, but there's definitely a problem there. Now we're looking next at the partners travelling with New Zealand citizens, visa waivers and partners from Australia. Now we're going to look at this section in a situation with partners travelling with New Zealand citizens, visa waiver countries, partners from Australia. We won't be looking at every factor, but just some concerns we have with the rules and how they are being applied. We'll link to the operational manual sections in the descriptions below, so when we talk about these various sections, you can see what we're referring to. Now, the operational manual, you'll refer to a letter and then a number. So you'll have, we'll have H5 2515F, which we'll refer to a number of times. That basically means section H5, subsection 25, subsection 15, then a subpoint F. So if you go to the link we'll provide, you can go down, you'll see what we're talking about. Any references to a letter than a number basically is as referring to the operational manual. Now, H52515F allows for the partner of a New Zealand citizen or resident to be considered as having a critical purpose for travelling to New Zealand if they are, and this is the wording from the manual, travelling with the New Zealand citizen or resident class visa holder. Now, under H52520, it considers a person will be considered a partner of a New Zealand citizen or permanent resident visa holder, or a resident visa holder, or Australian citizen or permanent resident, goes on, if they meet the requirements for partners specified in E4.1. Now we look at E4.1, I've linked to again below, provides a definition for partner which allows for marriage, civil union, de facto relationships, so basically covers the bases, with a New Zealand citizen or resident visa holder, and they are in a genuine and stable relationship. Now, those words, genuine and stable relationship, are defined in E4525. This is how we work with immigration law in New Zealand. We sort of follow the breadcrumbs. So yeah, E4525 defines that term as being genuine because it has been entered into with the intention of being maintained on a long-term and exclusive basis, and is stable because it is likely to endure. So that's what a genuine and stable relationship means according to Immigration New Zealand. Now what you'll notice there is that at no point in this last minute or so have I said living together, either currently or previously, because as far as we can see, that is not a requirement, part of the requirements for someone travelling with their partner, or what they call fetching. Yet we are seeing people coming to us with declined decisions stating that as a reason, even though they are living with their partner at the time the application is made. A requirement to be living together is not mentioned in E4.1 at all. It is mentioned in E4.5, but only in relation to family work stream visa instructions, which are visas granted under partnership. With this is not. Student visas for dependents, visitor instructions for dependents, and special work visas for partners of military visas, which none of those apply to a critical purpose visitor visa of this type. This seems to be the application of the rule which should not be applied. The requirement should be proving the relationship is genuine and stable, not on showing that they have been living together previously. And of course the application is being made while they are together and while they are living together at the time. So there is no requirement to prove that, but it is the case. That is the basis for the application of travelling with your partner. You're with them when you apply. Now this gets more confusing for Australians. This is the craziness we're going through. Now many of you will know that the allowance provided for visa waiver countries, where applicants from a visa waiver country who are in a relationship with a New Zealand citizen or resident and can show they have lived together previously, can apply for a CPVV. Now we are seeing what appears to be a tightening of those applications, which is disappointing, as it appears the interpretation of the rules is changing as to what living together means. They're sort of providing on there needs to be a certain period, but they're not saying what period, when actually it should be have you or haven't you, you have, that's met. However, those rules don't apply to Australians. Now, as strange as it may seem, Australia is not a visa waiver country. Okay? Instead, Australians get granted a residence visa on arrival, which is then cancelled when they leave. There's a list of them in the operational manual of visa waiver countries. Australia is not on it. So anything to do with visa waivers does not apply to Australia. Instead, Australians can apply for a border exception under another set of rules. Now, to make this confusing, the border exceptions generally are under sort of H5 and H6. For the Australians, it's under A15, which is in another A section of the operational manual. It's to do with administration. How applications should be handled, what the requirements are for the general process, character requirement rules, health requirement rules, the requirements of Immigration New Zealand, how they should handle things, those sorts of things. Not actually about visas themselves or visa types, but for some reason they've hidden away the Australian exception in A15.5 rather than putting it with the other ones in the H section. Now, the Australian exception is similar to the other visa waiver exception in that the proof of having lived together is a requirement. So both was it H6 for the visa waiver exception, A15.5, same general rules apply, but there's a couple of differences. Now, the first is that it is a one-step approach, that you only apply for the EOI, and you attempt to provide sufficient evidence with the EOI and in what is a 3,000 character text box. Now, typically immigration will come back to you and ask for more information, which seems kind of crazy when it was limited in the first place to this small amount of information. They just come and ask for more later rather than let you provide it in the first place. And the issue being is that you have to try and explain your relationship and your time together and your proof of your relationship and everything like that in 3,000 characters. Now, as a comparison, so far I've said about 7,500 characters in this video. So I'm already over double what your allowance is to describe your relationship and sort of how things got to where you were and where you live together, that sort of thing. Now, those from visa waiver countries are not expected to be able to sort of concentrate that information in such a small area. They're allowed to provide as much as they want. Now, you can provide documents as well with that, and you need to provide documents to show you've lived together, which is hard in itself at times if it is a short period living together. It seems they're making this whole thing much more difficult for Australians. You're having to provide this a small number of documents, this 3,000 character as a maximum, where if you're from a visa waiver country, you can provide a letter, you can provide a lot more documentation. Yes, there's an extra step, but I think for applicants, if it means an extra step and a small charge, it's much still with the ability to talk about your relationship and provide more documentation. They'd much rather do that than have this small one-pager where you're given such a tiny amount of thing to try and cram it all in there. Now, the second difference is that Australian applicants get granted a single entry residence visa instead of the CPVV visitor visa. Now, this does sound better sort of starting off with, but when you think about it, Australians get that anyway. If Australian arrives at the New Zealand border, the vast majority will get a residence visa on arrival. That's how it works. So if they were granted a CPVV, like actually Australians who get a border exception as a critical worker or a health worker will get granted that. They're granted a CPVV to come to the border. When they get to the border, they get granted a residence visa. That's just how it works for all the workers. But for some reason, they're given partnership applicants this extra step to go straight to a residence visa. And in both situations, it doesn't make a difference. It's a single entry residence visa, so it means you can come into the country. If you leave, you can't enter again. If you arrive in the country on a CPVV, you get to the border, here's a residence visa, you can't leave again, you lose the visa. Either way, it is the same end result, but it seems to be making a lot more complication for immigration and for applicants who just don't seem to see the issue. So there seems to be a little reason for the difference. One thing it does do is the application does appear to take longer than those going for a CPVV for visa waiver countries, because it's a longer application to process because it's a residence visa rather than a visitor visa. So there seems to be more hoops to jump through and more processing time on immigration's end. So Australians have to wait for longer than those from other countries. And the issue, this is not the end of it, the issue is increased when the partner goes to Australia to fetch their partner. Now, with any other country, this would be under H5 2515F, which doesn't require the couple to show evidence of living together, because as I said, it makes sense, at the time of their application, they are living together. So it doesn't need to be shown, because that's how it is. However, the applications we have seen, it appears that Immigration New Zealand are forcing the A15-5 requirements rather than allowing the H5 2515F requirements, requiring evidence to be shown that they have lived together, despite them living together at the time they apply. Now that means that Australians, as well as having to wait longer for their visas to be processed, also don't seem to be able to apply under the H15 2515F allowance of travelling with your partner, even though the operational manual doesn't actually prevent them applying under that. It seems to arise that the EOI form, the first form you fill out on the immigration website when you're applying for a border exception as a partner, when you say you are an Australian citizen, the form actually changes and it takes you down the A15-5 path. It doesn't allow you to apply for the critical purpose visitor visa. It goes down, no, you must go down A15-5, residence visa, show you live together. So Australians are forced down to take the worst path, despite being New Zealand's sort of sibling nation, a path that is worse than applicants being fetched from any other country. You can go to any other country, have an easier process to fetch your partner than from Australia. Now, we've reached out to the head of the Immigration New Zealand Border Reception team to clarify this. This is the case, and we'll let you know if we get a reply and what the clarification is. It isn't the only issue we are seeing. As I mentioned, there's an issue with Y330, but we are looking into those in more depth before we sort of come to you with mentioning what those issues are. But this one here, we are seeing a number of people being caught by it and being declined when really we don't think they should be. Unfortunately, the complaint process for the immigration isn't always the best, and it can be slower than just applying again, which leaves applicants, especially those overseas with their partner, with few options for a quick resolution. They've just been declined. The options generate, raise a complaint, look at 25 days for working days for immigration to respond. Try applying again. You could get through, you might not, depends who picks up the file. Immigration shouldn't depend on who handles the file. The rules should be fixed and clear and work. We're seeing way too many errors coming out of Immigration New Zealand right now on these border exceptions. But that's it for today. As I said, there are some more issues with the operational manual. We are looking into them. We'll come back to you those on a later date once we have more time to research them. We're also looking into the legalities of Immigration New Zealand holding on to application fees. When applications are withdrawn, they have not been processed, as we've seen with skilled migrants who pay thousands of dollars. They're sitting in queue, they withdraw because they've lost their job and they're not getting refunds. Now we're looking into the legalities of that because we think that could possibly be a breach of the law. We're looking into it, we're not certain yet. We'll come back to you when we on those when we have had a chance to look into them in more depth. We want to make sure that we give you the correct information, our view on them. That's it for today. There are some other issues, as we said, on what we're looking into with the operational manual, and we'll come back to you at a later date once we've looked into those. We're also looking into the issue with Immigration New Zealand not refunding application fees when the application hasn't been processed. Basically, they've got the fees, they've got the file, they've scanned it, and they're charging thousands of dollars to do that. So we're looking into that as well. We'll come back to you on that at a later date once I have more time to research it. Until then, if the video was helpful, please like it. It does help get the word out there. Subscribe if you want to be notified about future videos. And until the next time, kia kaha and stay safe.